Hello everybody. Welcome to another CEFTUS event. I am Dr. Derya Bayir. I will be the one who's chairing today's event. First of all, I'd like to thank CEFTUS for organizing this event. I guess many of you know CEFTUS very well, but let me say a few words about it before those for those who do not know CEFTUS. CEFTUS is an independent, non-partisan organization, aims to build a bridge between Turkey and the UK. It provides an open forum by endorsing expert opinion, facilitating debates, and conducts research on Turkey-UK relations and socioeconomic developments in Turkey and the surrounding region. Today we have two distinguished guests, Dr. Dilek Kurban and Professor Helen Duffy. I'd like to welcome them on CEFTUS' behalf. Dr. Dilek Kurban is a fellow and lecturer at Hertie School in Berlin. She obtained her PhD from Maastricht University of Law in 2018. Her dissertation received the Erasmus Dissertation Prize 2019 in Netherlands. She also holds a Juris Doctor from Columbia Law School and a Master in International Affairs from Columbia University. Her research interests include supranational human rights courts, state violence, legal mobilization, judicial politics, focusing on authoritarian regimes and regional focus on Turkey. She's the author of Limits of Supranational Justice, the European Court of Human Rights and Turkey's Kurdish Conflict, published by Cambridge University Press in 2020, which she will be talking about today. Kurban also published in various edited volumes and peer reviewed journals, including Human Rights Law Review and Columbia Law Review. Her research received funding from Columbia University European Commission, the Marie Curie, FP programs, and Marketer-Schafting. She worked as Turkey expert of the network of independent experts in the non-discrimination field. She reported to European Commission. Dr. Kurban also has an NGO background. Between 2005 and 2013, she worked for the Turkish Economic and Social Studies Foundation in Istanbul as the director of its democratization program, where she engaged in policy-oriented research. Actually, Dr. Kurban next year will be the Max Weber postdoctoral fellow at the European University Institute in Florence. As I told you already, Dr. Kurban will be speaking on her book. I congratulate her on her success. As a young lawyer who started to work in Istanbul in 1998, represented political prisoners, worked for the Human Rights Association and the Kurdish, and also be the member of Kurdish Lawyers Association in Istanbul. I myself litigated many cases before the ECHR. And I'm actually one of those lawyers and later academic who graduated with limited knowledge on human rights law and yet had to self-educate myself to litigate the cases of my clients who were subjected to horrendous human rights violation in the hope of assuring them a little justice, which Dilek is actually talking in her book. Mehmet Nuri Özden versus Turkey, Dilek also mentions in her book, was actually one of my cases. Yeah, it's interesting to see it in your book, actually. I'm also proud. Yet, as a relatively still young lawyer and academic, I didn't think that the story of my generation would be written so quickly. But anyway, it's nice to hear it while I'm still alive. And that's why when I had a chance to actually look at your book, and I find it really, really interesting. Anyway, our second guest is Helen Duffy. She's a professor of international human rights and humanitarian law at the University of Leiden. And she runs her own international legal practice called Human Rights in Practice. And she has litigated leading cases in the European, inter-American, African, and international human rights systems on a range of human rights issues. She's currently also supervising director of the Turkey Litigation Support Project, supporting litigation on human rights abuses in the period following the attempted coup of 2016. Her book includes The War on Terror and the Framework of International Law, Strategic Human Rights Litigation, Understanding and Maximizing Impact, and the law applicable to armed conflict with Bayir and Dilek, and Strategic Litigation Impacts, Torture in Custody, OSI publication focusing on the litigation of torture in Turkey, Kenya, and Argentina. Before leaving the floor to our guests, let me say a few things about the logistic of today's talk. I will first invite Dr. Kurban to talk for about 25 minutes. And then Professor Duffy will deliver her talk, including some remarks on Dr. Kurban's book, approximately for 10 minutes. After that, I will open the floor to for questions and further discussion, almost for 45 minutes. While our guests deliver their talks, the audience can write their questions on the comment box, chat box. I will also, at the end of their talk, I will ask this question to our guests. And now I'm just leaving ground to Dilek for her presentation.
Thank you very much, Derya, Dr. Bayir, for this kind introduction, and hello to everyone. And good afternoon. I'd like to thank the Center for Turkey Studies, CEFTUS, for hosting this event. I owe special thanks to Dr. Cengiz Güneş for inviting me to present my book in this forum. And Professor Helen Duffy has kindly agreed to discuss my book, and Dr. Derya Bayir to chair the event. And I thank both of them for their help, time, and support. So I have a PowerPoint presentation, and let me start by, I hope you all see this. Okay, so I have about 25 minutes. What inspired this book was an encounter in summer of 1998, actually, the year that Dr. Bayir started lawyering in Istanbul. I was a young graduate student at Columbia University, SIPA, assisting a team of American human rights lawyers in their fact-finding mission in Turkey's Kurdish region. We were hosted by the Diyarbakır Bar Association in the Kurdish region. My task was to translate the interviews they made, the American lawyers made with Kurdish lawyers engaged in criminal defense and ECHR litigation on behalf of victims of gross violations. I was struck by the resilience of Kurdish lawyers who themselves were victims of state violence and yet engaged in ECHR litigation under emergency conditions and won groundbreaking judgments which set precedent for the entire convention system. Among these lawyers was Tahir Elçi. Like 24 other Kurdish lawyers, Tahir Elçi was targeted for his human rights work at the time and held in incommunicado detention, and prolonged pretrial detention on accusations of terrorism. During this time, and I'm speaking about mid-1990s, he was threatened with death and heavily tortured. Tahir then became a dear colleague and friend. We developed a close professional relationship and friendship over the years. On 28 November 2015, he was assassinated in circumstances implicating state responsibility. To this day, the perpetrators remain unidentified. Tragically, his killing will most likely remain unpunished and become yet another case of impunity against which Tahir fought during his entire professional career. The photo of my book that you see here was taken at his funeral, displaying generation of Kurdish lawyers that Dr. Bayir also belongs to, whose human rights advocacy has been a source of inspiration for my work. In these photos, we see an occupying military force, masked special operation teams, completely destroyed towns, and civilians carrying their few remaining belongings and fleeing into safety. But this is not Grozny under Russian siege. It is not Aleppo during the civil war in Syria. These are the towns of Cizre and Shirnak, among others, in Turkey's Kurdish region. In July 2015, the Turkish military launched an offensive in the Kurdish region. It went into densely populated towns with thousands of combat-ready troops and armored vehicles against urban militants of the Kurdistan Workers' Party, the PKK. The military bombed and laid siege to entire towns without any regard of the presence of civilians. From August onwards, the government declared round-the-clock open-ended curfews in more than 30 towns and neighborhoods, which lasted several days, weeks, months, or years. Over 1 million people were locked up without access to food supplies, water, electricity, power, and emergency health services during the long winter months. No one, including the sick, elderly, pregnant women, children, disabled, was allowed to leave without authorization. Neither was anyone allowed to enter, including parliamentarians, humanitarian workers, and journalists. According to the United Nations, by the end of 2016, some 1,200 civilians had been killed by indiscriminate use of tanks and heavy artillery inside residential areas. Many of them died for lack of access to emergency health services. According to the Turkish government, over 350,000 residents were displaced. According to domestic and international human rights NGOs, numerous were disappeared and tortured. Not a single military or security officer has been held accountable to this day. One of the civilians who was killed during the curfews was Taybet Inan, a 57-year-old mother of 11. On 19 December 2015, at around 7 p.m., she was shot to death outside her home by Turkish security forces. She was on her way back from visiting a neighbor across the street. Her crime, quote unquote, was to step out during a round-the-clock curfew in her town of Silopi in the Kurdish region. While she lay wounded in front of her doorstep, her family called for an ambulance, which never arrived. Her brother-in-law Yusuf, too, was shot when he stepped out to help her. The family called the emergency policing line again, this time to ask for authorization to go out in order to bring an ambulance themselves. The authorities said they would be safe to leave if the family carried white flags. The family obliged, but were nonetheless shot at by the security forces. After several failed attempts, the family watched Taybet and her brother-in-law Yusuf bleed to death. The family were able to retrieve Yusuf from the courtyard into the house, but Taybet's body remained out on the street. For one entire week, her dead body lay in front of her house while her family repeatedly begged the authorities for permission to retrieve and bury her. Once again, the family was told they could leave as long as they carried white flags. They obliged, only to be shot again. This time, Taybet's husband, Halit, got injured. Luckily, he survived. One of Taybet's sons later wrote, quote, "My mother remained on the street for a whole 7 days. None of us could sleep. Worrying dogs would come around, birds would perch on her. As she lay 150 meters away from us, we too died." End quote. On 25 December, Taybet's body was finally taken from the street by the authorities to the morgue of the local hospital. When the authorities buried Taybet 18 days later, they allowed only 2 of her children to be present at the funeral. Her husband and remaining 9 children were denied a farewell. Taybet was buried without a religious ceremony. So individuals trapped in the curfew zones did precisely what would be appropriate in a country that claims to be a democracy under the rule of law. They went to courts. They first went to Turkey's constitutional court, requesting the court to issue an interim measure by ordering the government to end the curfews and to either cease the military operations altogether or at least carry them out in accordance with international legal standards. One after another, they failed. According to the Constitutional Court, there was no serious danger requiring an interim measure. The court did not even review whether the curfew decisions lacked a legal basis, as argued by the petitioners, let alone engage in a proportionality analysis. The ECHR's response, the ECHR being the European Court of Human Rights, was not much different. Out of the 34 applications made by over 160 applicants, the ECHR granted interim measures in only 5. In 4 of these, the Turkish government defied the interim measures, resulting in the death of the applicants. In the remaining 29 cases, the ECHR relied on the decision of the Turkish Constitutional Court, which it found, quote, to be relevant and potentially capable of providing interim relief for the applicants, end quote. Taibet's family was among the petitioners. Before applying to Strasbourg, they sought help from the Constitutional Court. Taibet's petition reached the Constitutional Court on 6 January 2016, after her body was taken off the street. The family requested a very specific interim measure, the return of Taibet's body so that she could be buried properly with a religious ceremony. Despite the urgency, the Constitutional Court did not respond. Meanwhile, the day after Taibet's family petitioned the Constitutional Court, the Turkish government amended the relevant regulation, stipulating that bodies not claimed by families within 3 days would be handed over to local authorities for burial. On 8 January, the family petitioned the ECHR. That night, the authorities went to Taibet's family home and asked her illiterate son to sign a document, which was later found out to state that the family had until 9 a.m. the same day to claim the body, or otherwise the authorities would bury Taibet in a place of their choosing. By the time the rest of the family was informed, they were too late. Taibet was buried by the authorities. The lawyers informed the ECHR immediately and insisted on their request for an interim measure, this time to enable the family to at least hold a religious ceremony by Taibet's grave. The ECHR rejected. On February 2nd, nearly 1 month after the filing of the petition, the Turkish Constitutional Court finally issued its decision, rejecting the request for interim measures on the grounds that Taibet had already been buried. 5 years after the filing of the individual petitions in the curfew cases, the Constitutional Court is yet to issue a judgment as to whether the Constitution and the Convention have been violated, with the exception of a case concerning the town of Cizre. As for the ECHR, in January 2019, it rejected all pending cases on grounds that the applicants did not exhaust available domestic remedies, first and foremost, the constitutional complaint mechanism. So, how has all of this been possible, right? After all, Turkey is an EU accession country since 2005. This status suggests that Turkey has fulfilled the EU's Copenhagen political criteria, which includes the protection of minorities and human rights. Turkey not only ratified the ECHR, the European Convention on Human Rights, as early as 1954, but is actually among the drafters of this convention. Finally, Turkey has been subject to the ECHR's compulsory jurisdiction since 1990. So clearly there's a puzzle here. After all, the European Convention system has been declared as the world's most effective human rights regime. There's a widely shared claim that the ECHR is the world's most effective supranational human rights court. Furthermore, the ECHR is not new to the Kurdish conflict. It has built a sizable case law on this issue since the 1990s, finding multiple violations of the convention in hundreds of judgments, including violations of gross human rights violations. And yet, there's been no fundamental change in Turkey's policies towards the Kurdish conflict. State violence against Kurdish civilians continues unabated, as I have described. Security forces who committed these crimes remain unpunished. Non-violent Kurdish dissent continues to be criminalized. Kurdish human rights lawyers continue to be arrested, intimidated, and jailed. Elected Kurdish officials continue to face judicial repression for contesting official policies and demanding equal treatment and cultural recognition for the Kurds. Currently, as we speak, dozens of Kurdish members of the parliament and mayors elected, in Turkey mayors are elected, are in prison, many of whom are being held in prolonged pretrial detention since November 2016. In addition, Kurdish mayors have been stripped of their elected seats and replaced by government-appointed bureaucrats, so-called trustees. Certainly, Turkey's extremely poor human rights record derives from complex historical, political, and sociological domestic factors, which I discuss at length in my book, but which I will not go into at today's presentation for lack of time. Now, that said, the ECHR's share in this outcome must also be addressed, particularly in light of a vast academic literature attributing to it a positively transformative role. This brings me to my research question. So what are the possibilities and limitations of effective review by a supranational human rights court of authoritarian regimes engaged in state violence against minorities? I seek answers to this question by taking the ECHR's engagement in Turkey's Kurdish conflict as a case study and hope that my conclusions are also generalizable for other contexts, such as ECHR's involvement, for example, in the Chechen conflict in Russia, but also perhaps the inter-American system. Now, a few notes on the concept of effectiveness that I'm referring to. My focus is the effectiveness of Dchr and not compliance with its rulings, and it's important to emphasize this. While compliance is certainly an aspect of effectiveness, I find theoretical scholarship too limited in its scope in defining the effectiveness of supranational adjudication as the ability to compel state compliance. Placing government's execution of judgments at the center of inquiry shifts the attention away from supranational courts, takes their rulings at face value, and thus misses the chance to meaningfully assess their effectiveness. I understand effectiveness to have two essential components. The first is supranational courts' willingness to make full use of their adjudicatory tools and resources. This is the top-down dimension. And secondly, their openness to legal mobilization of minorities who are failed by their own judicial systems, and this is the bottom-up dimension. Both of these are independent of the court's ability to actually change government behavior, but concern their willingness to keep pressure on authoritarian regimes by documenting state violence, exposing the complicity of domestic judiciaries, and calling for real policy change, as well as by hearing the justiciable claims of minorities through being and remaining open and responsive to their legal mobilization. In sum, with respect to authoritarian regimes, and I'd like to emphasize that I'm not speaking about liberal democracies here, I understand effective supranational adjudication as one which effectively substitutes domestic judiciaries who are complicit in violence against minorities. Now, when you look at Dchr scholarship, you see that there's a dichotomy between the old and new member states. So accordingly, old member states are established democracies with strong rule of law traditions, which need only fine-tuning of their legal systems. Whereas newcomers are post-communist nations with fragile democracies and weak rule of law systems who need structural guidance by the Dchr. Similarly, scholars of constitutionalism in the Dchr system categorize member states according to two dates. They argue that the basic formula of an entrenched written constitution, a charter of rights, and constitutional judicial review was replicated in every new constitution adopted in Western Europe since 1949. Constitutional scholars depict the early 1990s as the second phase of constitutionalism, this time eastbound. Accordingly, the accession of Central and Eastern European countries has required the Dchr to assume the role of a constitutional court. What is really striking, which struck me really when I looked at this literature, is the treatment of Turkey. It is a perpetual footnote in this relationship, in this literature, I'm sorry. At best, there's a recognition of the exception, but often in a footnote or literally in a parenthesis. So the case of Turkey has been almost completely overlooked in the literature. So evidently, there's a significant gap here. The old new member states dichotomy does not capture the case of Turkey. As I said earlier, it has been there from the beginning. Yet the basic formula never applied to this country. When you look at the constitutions adopted in Turkey after the Second World War, they did not produce a rights-based, but an authoritarian constitutionalism. Neither has Turkey been going through a linear democratization process. Nearly 70 years after its transition to a 3 times directly interrupted polyarchy, Turkey remains a country where some of the freedoms regarded to be sine qua non of democracy are selectively and subjectively adhered to. Unlike the transition to democracy from military dictatorships in Southern and totalitarianism in Central Eastern European countries, the transition in Turkey was from an authoritarian single-party regime to polyarchy, where the state system has remained anti-democratic. In other words, there's never been an identifiable rupture with the ancient regime or a decisive break with an anti-democratic past. The regime change in Southern and Central Eastern Europe was coupled with constitutional moments, right, where new political elites drafted democratic constitutions, which were then handed over to new courts, constitutional courts, often tasked with transitional mandates. So in these states, democratic transition, constitution making, and transitional justice were interwoven processes. Certainly, recent developments in the children of post-communist transition, such as Hungary, Poland, Slovenia, certainly cast shadow on what seems to be premature assessments on the durability of these transitions either. But coming back to Turkey, the constitutional regime adopted by the junta after the 1980 coup has survived the transition to electoral politics and has since been preserved and expanded by all civilian governments. Today, laws governing virtually every walk of public life in Turkey, ranging from political parties to media, elections to civil society, higher education to high judicial institutions, have been drafted by the junta. Notwithstanding EU-induced amendments in the 2000s, the authoritarian spirit of these laws remain. Finally, Turkey has been governed by some state of exception during half of its republican history. Few words on the theory and method. In seeking answers to my question, I primarily engage with two theoretical and methodological approaches. First, I resorted to socio-legal scholarship to see how Kurdish lawyers mobilized the ECHR to bring an end to state violence and to achieve political and cultural rights for the Kurds. My book builds on the empirical data I gathered over the past 15 years through semi-structured interviews, participatory observation, conversations, and collaborations. In line with the bottom-up approach of the legal mobilization literature, my focus was Kurdish human rights lawyers, but I also interviewed British human rights lawyers, Turkish government officials, Council of Europe officials, EU officials, the ECHR judges in respect of Turkey, and lawyers at the courts. Second, I looked at the ECHR's responsiveness to Kurdish rights claims. For that end, I employed the doctrinal method of legal research. My primary focus was the court's jurisprudence. I analyzed not only its judgments, but also its inadmissibility decisions, friendly settlements, and strikeout rulings. I did not confine myself to majority opinions, but also studied the opinions of dissenting judges. Finally, to also assess the court's effectiveness in terms of compliance, I studied the interim resolutions and resolutions of the Committee of Ministers and the reforms adopted by the Turkish government to implement those resolutions and execute the ECHR judgments. Now, which conclusions can be drawn regarding the European Court's oversight of state violence in the Kurdish region? First, the ECHR has never made full use of its review powers, namely the tools and resources at its disposal. Not even during the peak of its engagement in the Kurdish conflict, which is the second half of the 1990s and early 2000s. Although it issued hundreds of similar judgments in nearly identical cases of torture, enforced disappearances, extrajudicial executions, and forced displacement, the ECHR has never said that the emperor was naked, namely that the Turkish state was engaged in organized and discriminatory violence against a part of its population, and that this violence was carried out and covered up by the entire state apparatus, including the judiciary. And this is not due to inherent limitations of supranational review. The Inter-American Court of Human Rights has shown that it is legally possible to find a state practice of violence on the basis of one case alone. Here I'm referring, of course, to the famous Velázquez Rodriguez versus Honduras, the first ever judgment of the Inter-American Court of Human Rights. The ECHR simply did not want to do that. Second, the ECHR's reluctance to acknowledge the absence of the rule of law in Turkey became all the more pronounced with the Council of Europe's enlargement. Preoccupied with its docket crisis, the ECHR endorsed Turkey's impunity regime by approving a reform law, which was adopted in 2006, which gave Kurdish victims of gross violations compensation, but not justice. Thereby, the court went against its own judgments, where it had repeatedly said that there can be no effective remedy without holding perpetrators accountable for their crimes, and that compensation would not be enough. A final factor explaining the ECHR's ineffectiveness is its rigid application of the subsidiarity principle. Over the course of its engagement for 3 decades, the court has first-hand witnessed the Turkish judiciary's complicity in covering up the gross violations against Kurdish civilians. And yet, in applying its procedural rules and substantive doctrine to these cases, to the Kurdish cases, the ECHR has always acted on the assumption that Turkey is governed by the rule of law. Now, why does Turkey still matter? Scholars have been generous in their assessments of the effectiveness of the European Convention system. Their positive conclusions have been possible because they completely overlooked the Turkish case, or at best treated it as an anomaly, as I mentioned earlier. In reality, the effectiveness of a supranational human rights court can best be assessed on the basis of its engagement in hard cases. And in the case of the European Convention system, I argue, Turkey is that hard case. Why is that? Long accepted and treated by the European Convention system as a liberal democracy, Turkey is in essence an authoritarian regime. Seemingly, it has been an electoral democracy since 1950. In reality, electoral competition has never been a level playing field. Certain segments of the population, first and foremost the Kurds, but not just them, have always been denied equal political participation, both during and between elections. Political party closures, the 10% electoral threshold, and the imprisonment of elected politicians are only some of the legal strategies that the Turkish state has employed towards that end. Turkey has never adhered to the substantive sine qua non of liberal democracy, first and foremost human rights and minority protection. Its political culture has never tolerated democratic dissent, particularly on sensitive issues concerning nationhood. The judiciary has never acted independently from the executive. More importantly, it has not strived to do so. Despite their formal independence until recently, Turkish courts have fully cooperated with authoritarianism during military and civilian rule alike. But the European Convention system itself also has impeded the court's effectiveness in Turkey. There are two principal reasons for this. The first is the ECHR's deference to Turkey's terrorism defense. The court readily accepted Turkey's argument that gross violations were unintended consequences of counterterrorism. Granting Turkey a very wide margin of appreciation, the court has never questioned the necessity of prolonged emergency rule in the Kurdish region, which lasted 15 years, nor did it review the proportionality of emergency measures as one would expect from a human rights court. The second factor explaining how the European Convention system has impeded its own effectiveness has to do with realpolitik. Both during and after the Cold War, Turkey's geostrategic significance for Europe has insulated its domestic policies from external pressure. This, I argue, is the main reason why the Council of Europe member states have never resorted to available enforcement and sanction mechanisms against Turkey. They tolerated successive military interventions by never suspending Turkey's membership, and resorted to the interstate complaint mechanism only once after the 1980 coup, only to reach a problematic settlement with the Turkish government. Furthermore, no infringement proceeding has ever been filed against Turkey for its non-execution of ECHR judgments. Most recently, for example, its ruling calling for the immediate release of Selahattin Demirtas, a prominent Kurdish politician and former parliamentarian. And this was a Grand Chamber judgment from last December. So this is my last slide. What does the Turkish case tell us? It has, I argue and believe, it has significant implications for scholarship. Existing theories on the ECHR's effectiveness need to be revised on the basis of empirical case studies of the court's engagement and impact in authoritarian settings. Recent developments in new member states such as Poland, Azerbaijan, Hungary, Russia render such rethinking all the more necessary. But the court too needs to develop a differentiated approach. In applying its evidentiary rules, such as those concerning burden of proof and evidence, interpretive tools such as margin of appreciation, and substantive doctrines such as positive obligations, the court should be mindful of the fact that subsidiarity cannot be a fit-for-all principle in its relations with domestic judicial systems. It is only after scholars and judicial practitioners adopt such a differentiated approach that we can meaningfully assess the ECHR's effectiveness in authoritarian regimes which engage in violence against their minorities. As much as we would all desire an ideal world where individuals can find justice at the courts of their own countries, the reality is that millions of European citizens are still dependent on Strasbourg for justice. While the court has justified grievances about its workload, efficiency can never justify partnering with authoritarian regimes and legitimizing their repression of minorities and dissidents. Thank you.
Thank you, Dilek. Thank you very much for this very stimulating and thought-provoking talk. Your effort to understand to what extent supranational and supranational adjudication and transnational mobilization are capable of impacting human rights practices and policies of authoritarian regimes is very interesting one, and then also the possibilities and challenges the supranational court actually can offer is really, really interesting one. And I'm sure many of other interesting arguments and questions you raise and provoke in your book will be picked up by the featured researcher, and I'm sure will be a great contribution to the literature. Thank you very much again. And now I'll give the floor to Professor Duffy, and you have 10 minutes to respond to the Dilek's talk today, as well as her, your insights about on her book. Thank you very much.
Well, thank you so much. I hope you can hear me well. Coming across fine, thank you.
Yes.
First of all, thanks so much for the invitation to speak about this really excellent book. And I do want to underscore that it really is an excellent book. It's a long time since I've read an academic book from cover to cover. And it's an even longer time since I've enjoyed reading an academic book from cover to cover. And it really is an incredibly rich book, and I would commend it to everyone. It's definitely worth a read. I think it's impossible for Dilek to do justice to that book in 25 minutes, and it's certainly impossible for me to do justice to the many issues that it raises in 10 minutes or so. But I'm just going to make a couple of observations and raise perhaps a few thoughts or questions for further conversation. My first couple of comments are maybe might come across as slightly superficial, but I want to make them anyway because I think they're important. The first thing to say is that it's beautifully written, Dr. Kurban, if I may say so, and that's actually incredibly important. I think this book is a good example of how important that is, because in the way that the book is written, I think you really manage to, on the one hand, have a thorough academic text, and on the other hand, to really weave in the narrative of real people's stories. And this is what human rights is about, of course. It's not ultimately about the article numbers and whether or not the procedural rules of the court are the right ones or are being followed. It's about the stories of real people and how their human rights have been so profoundly impacted. And I think you managed to tell those stories beautifully and in a very meaningful way. It's also a personal book. You see right at the beginning that, in a wonderful phrase, that you're reflecting on the personal through the lens of the law. And that sounded like quite an ambitious thing to do, but I could see what you meant as the book unfolded. And I think you've done incredibly well in dealing with really difficult macro issues, dealing with the role of one particular supranational body, weaving it in, cross-referencing to the inter-American system, where of course I worked for a long time, and still managing to tell real people's stories in a way that isn't abstract. One of the things that struck me, my recent work, I'm not a Turkey expert in the way that many of you are, of course, but as was mentioned in my recent work, I've had the privilege to be able to work with this Turkey litigation support project in a number of cases before the European Court, trying to offer some support to the many lawyers trying to see justice done on a whole host of different human rights issues. And one thing that really struck me when I was reading the book was just the extent of the continuity from your historical analysis, largely your analysis that looks at how these issues have been dealt with in relation to the Kurdish conflict and the situation in southeast Turkey, and how so much of that really resonates very directly with what's going on today. And you mentioned this again in your presentation. So many of the issues that we're dealing with, in a sense, day to day, issues like the removal of politicians, the disintegration of democracy, the attacks on freedom of expression, the implications for democratic institutions, the widespread impunity. All of these could be discussions. When you're discussing in the book what happened a number of years ago, they could very much be conversations about what's happening today. And that prompted the question for me, in a sense of, to what extent this situation, let's call it, in southeast Turkey, this widespread repression and the responses to it, or the failure of those responses internationally, to what extent they really did pave the way for what has come. What is the relationship between what happened before and what's happening today? And also perhaps a broader question that struck me as someone who spends a lot of time looking at counterterrorism in a global context, the so-called war on terror and the devastation that has wreaked on human rights globally. It also occurred to me very strongly that what we've seen in Turkey for a very long time, of course, before it shot to the top of the international agenda with 9/11, what we've seen is the misuse of the label of terrorism and of counterterrorism. We've seen the same kind of massively expansive use of criminal law against terrorism in a way that really goes against the notion of criminal law and the basic principles of legality and certainty and due process, individual responsibility, etc. So just to what extent, in a sense, this story that you're telling, this legal and political and social story, was also in a sense the harbinger of what has come after with the global war on terror. Perhaps if we had listened and learned more lessons as a global community from what happened in Southeast Turkey, we would have done better with our war on terror, which continues to spread its reach and to spread these abusive counterterrorism policies and laws around the world. I think one of the things that's interesting about the book is, although you're focusing on the role of supranational litigation in the European Court of Human Rights, you also recognise something really important, I believe, as a litigator and as someone who's practiced and analysed litigation for a long time, which is that you can't look at litigation in a vacuum, right? So you have to look at what role does that court have, whichever court you're looking at. What role do those legal processes have in conjunction with others? So of course, in Turkey, when we think of the impact of the European Court, we can think of how that was informed by and influenced by the geopolitical realities of the importance of Turkey, the relationship with the EU, that ongoing saga over time, and how that influenced the extent to which the European Court of Human Rights provided judgments that were seen as benchmarks, perhaps, for what Turkey had to do in order to meet certain standards of the European Union. But you also highlight in your book, I think, the failures of international community in many of its dimensions, the inadequacy of many responses, not only of the courts, but of others. And I think it's important to keep assessing the role of the court in that broader political framework. You also raise, I think, quite provocative and interesting questions about the role of civil society and lawyers. You talk about mobilization, which in my view is an incredibly important piece of the puzzle. It's one of the important impacts, I think, of litigation can be mobilization of civil society. But you also, I think, in a fair and balanced way, ask some questions about the limitations of mobilization as well. And I think you suggest, in a sense, that, that perhaps there hasn't been as much strategic and cohesive efforts to use the European Court and perhaps other litigation initiatives. And I thought it would be interesting to hear a little bit more about that. What, to your mind, would a more cohesive and strategic approach to using litigation by civil society or by lawyers in Southeast Turkey have looked like? You're certainly not blaming them. I mean, on the contrary, I think you expose the incredibly remarkable work that's been done in the most difficult circumstances, but you do also raise these questions, I think, of it not perhaps having been as strategic approach as it might have been. Turning to look at the role of the European Court, and just to make a couple of comments on that, which is really the heart of your research, which is what is the role of this particular form of supranational justice. Most of what you say on that resonates with me very strongly, and I can very much agree with what you say in terms of the limitations of what the court has done. And I think where your analysis is very valuable is really in highlighting in quite a nuanced and detailed kind of way how the court could have done more and the process could have done more and how it has fallen short in this particular context. For example, you know, the reluctance to really identify and name a practice and policy, the reluctance of the court, which goes way beyond Turkey, to talk about discrimination, the consideration that it's not necessary to look at whether there was discrimination, where actually it's fundamental to understand violations, to understand whether they have a discriminatory motive. So in a number of different ways, I think you do expose the limitations in the approach that the court has taken in particular cases and more broadly. But to push back a little bit, Dilek, because that's my job as well, not just to tell you how fabulous it all is. To push back a little bit, one could also say, what are our expectations of this supranational body? Clearly the role it takes, how robust it has to be, how much deference it gives has to be contextual, and I agree on that. It has to be more deferential, where that will prompt justice on the national level. It has to be more active and exercise more rigorous oversight, where there's no real prospect of justice domestically. I think they've fallen on the wrong side in that analysis in Turkey. They've been extremely deferential to, for example, the Constitutional Court, absent evidence that that court is really committed to and doing justice. But is it realistic? I mean, to some extent in the presentation of this discussion, there's also a sense, I think, that the European Court of Human Rights has failed to solve the problem. It has failed to end repression. And so I guess I would ask you, do courts ever do that? You know, I mean, I've looked at litigation in many contexts for several decades now, and my sense, and also analysed the impact of litigation, and my sense is that judgments and courts almost never solve problems, but they might contribute to solutions. And they might contribute in a variety of different ways. And so I think in looking at effectiveness, and I agree with your analysis of the need to look at that more broadly, I think we need to look at the impact that the court has alongside other actors and other developments, if you like. And I think we have to look at the impact in lots of different ways. And I did wonder if your analysis perhaps didn't do justice to some of the ways in which the European Court had contributed to progress, albeit insufficient progress, but to progress. For example, on a legal level, the contribution that was made to strengthening procedures and safeguards in Turkey, albeit not in a linear way. And of course, some of that progress we've now seen steps back from, but there clearly was an impact of certain judgments on legal development. What about institutionally in the development of institutions, imperfect institutions, insufficient, but again, some contribution. Mobilization, you do talk about. I wondered, you know, it seemed, I'm struck by how much advocates and lawyers, Turkish and Kurdish activists and lawyers believe in the court and believe in doing justice and continuing to do this. And so I asked myself why, if it really doesn't make a difference, or on what level is it making a difference for people in their sense of empowerment, in their ability to at least expose the violations, to expose the lack of justice in that process, and to contribute to a narrative that at least is a more nuanced and balanced narrative that hears the victims and hears the advocates. So certainly far from perfect, and I'm not here to be an apologist for the European Court, which I think does need to do much more, and I think your analysis is excellent in highlighting that. But I think we also have to be extremely nuanced, and I'd just like your reactions to that, because you are a nuanced scholar and your book is extremely nuanced. But in thinking about the ways in which litigation contributes to impact, and of course through that in thinking about how we can make it more effective. Ultimately, the European Court, like any other court, certainly on the international level, is as good as the clout that is, the weight that is put behind it, the weight of other states in enforcing, the weight of civil society and other actors in mobilizing and in using those judgments as tools. They rarely solve problems, but they provide tools that we can use and that we need to use better. So those are just a few observations on excellent work, and I thank you very much for it.
Thank you very much, Helen. You have many questions actually, and I'm sure Dilek is she will respond them in great detail now. And please, Dilek, I mean, if you want to answer.
Thank you very much, Derya, and Helen. Thank you so much. This is so precious. Hearing all of this from you, your insights, given your academic and practical expertise and experience in both European and American, but also beyond, in the human rights system. So thank you very much for the support. I do appreciate that very much. I'll go in the order of the questions that you had asked. Now, to what extent did the past pave the way to what's going on today in Turkey? I think it had multiple impacts, some positive, some negative. First, let's say on the positive side, I think which of course didn't, I think violence, the scale of the violence has really, in a way, has led to an unprecedented mobilization on the part of Kurdish human rights lawyers, which then had a sort of a multiplier effect, really, which then led to other minorities in Turkey to also mobilize, not so much, not so strategically, not so aggressively, but, minorities that would have never dared, and I'm talking about non-Muslim minorities, Armenians, Greek Orthodox, they also started to litigate before the Dchr. And then, of course, not to mention the precedent that this has set for Chechen and then other minorities in Russia to mobilize against Russia. So there's that. But I think a lot of it has been, of course, negative. When you have so much state violence, which impacted generations and really disabled not just ordinary people, but a civil society and lawyers and politicians, sort of, erase so many people from the picture. Some of the first generation Kurdish lawyers that I interviewed, and I had not even heard of them before I started working on the book. And I know, a lot of the Kurdish human rights lawyers, they've stopped it. They're doing private practice in Istanbul, Ankara. No one even knows about them, not even the new generation of Kurdish lawyers. So I think that really has just had diminished in a way the power, or the ability of civil society and the legal community. But I think it also created a fatigue in a way in the international community at large. And I think that's just been one of the very adverse effects. It's almost like the Palestinian and Israeli conflict in a way. It just created this kind of, oh, it's the Kurds again, it's the Kurdish question again. So much so that that the story that I started with, it happened in 2015. It should have. And the main difference between then and now, also, I have to emphasize, is that then Turkey was not even a candidate to EU for EU membership. Now it's an accession country. It should have created an uproar in Europe, but has not. Many people are not even aware of that. And I think so. I mean, there's just so much that I can say, but just to highlight some. And the misuse of the counterterrorism, and to what extent that has perhaps set a precedent in a way, or a model. You're absolutely right. And one of the things that Kevin Boyle, the late Kevin Boyle, a legendary, Irish human rights defender who was very much involved in the early stages of, as you know, Kurdish strategic litigation. One of the first things that he said, and he's from Northern Ireland, and he was part of the civil rights movement there before lawyering, etc. So he's seen state violence, but he was struck. He said when he arrived in Diyarbakir, he was just struck by so, and how similar it seemed to him on one hand, but also how much more it was compared to the British government's counterterrorism method. So in that sense, it wasn't the first thing. There was already a precedent in Europe, but of course, what happened in Turkey exceeded that. And you are so right, particularly because Turkey was accepted as a democracy. So it sort of like created this understanding that happens in democracies, that it is okay. And as I said, the emergency rule in Turkey stayed in practice for 15 years. It's just unbelievable. Failures of international community. I mean, I'll get to that in answering your last question. In terms of legal mobilization, Kurdish legal mobilization, what would a coherent strategic litigation achieve? I mean, as you also say, I don't, I try to be, and I, of course, also always, one has to be fair, because they have and continue to operate under incredible conditions. State violence is just so prevalent. There are all kinds of structural obstacles. Language issue is still a big issue. Derya mentioned earlier how she's taught herself English, and she's one of the very, very, very few handful, really, Kurdish lawyers who speak English, or any foreign language, and that's just an example. But I think what it still would have, having said all of that, they could have still done more. And I think that Charles Epp, in his book on legal mobilization in India, he talks about how in India lawyers have this tendency to practice alone, and they don't cooperate much. And we have the same culture in Turkey. not just among the Kurdish lawyers, it's a general legal community, also academic community. And I think that was you see that, you know, they continue to litigate alone, do not, I think, share sufficiently information, strategy, they don't collaborate sufficiently. The language problem, of course, is a barrier in terms of forming transnational links with you know, experts like Helen, for example, which they did in the 1990s. Another problem is there's a revolving door between law and politics in Turkey. And when you look at the lawyers that I met in 1998, many of them are in politics now. You know, they've become members of the parliament, etc. And I understand why they do that, but I think that just creates a big problem, because then all of that valuable, you know, they lose it. And as a result of all of this and more, they've made major mistakes. Also recently, there's a famous Roboski case that you know, people who are familiar in Turkey would know. A case was a major case that they would have definitely won in Dchr, because there's a precedent for that, concerning the aerial bombardment, indiscriminate bombardment of civilians, including children, resulting in the death of 37 of them. It was rejected on a very procedural, almost, I have to say this, you know, silly mistake. That kind of stuff unfortunately happens. And I said, I think it's because, in a way, they don't take law seriously enough sometimes. They may do that, I think, partly because, again, you know, they're too busy, you know, being subject to legal repression, state violence themselves and their clients. Now, on your last question, Helen, and I mean, of course, I could talk on and on about this. You're absolutely right. You know, we of course, we should not expect too much from, I mean, everything from supranational courts. And do courts ever end violence? Certainly not. But I think what we can expect, and that's what I mean by effectiveness. I don't think that they should strive for that as far as authoritarian regimes are concerned, not to really strive for changing state behavior fundamentally in a way. But I think there are a few things that we can expect, and that the Dchr has, you know, utterly failed. One is, of course, coherence. I mean, when you look at the jurisprudence of the Dchr on the Kurdish conflict, and not just that, it's so incoherent. It's really, you know, it contradicts itself. The example I gave on this compensation law, for example, effective remedies. It can be, and that's, I think the question is, what's the function of a human rights court, right? I think the function should be, I think its main function is protect victims and to be victim oriented in its adjudication. I found the Dchr to be too often government oriented in a way. They seem to they can forget the victim and worry too much about how government would react, and of course, not to mention the Ducat crisis. Use all of its tools. I mean, I think that's one of the main argument that I'm making, is that the court had these tools. For example, going back to the emergency paradigm that you also mentioned, counterterrorism. The ECHR, back then the commission, had actually used that against Greece, right? When the junta came to power in Greece and declared an emergency nationwide, the European Commission actually said, wait a minute, I'm going to look into this. You know, is there really an emergency threatening the life of the nation? And the junta had argued that there was a communist takeover threat. And what the commission did is they went to Greece and they did a fact-finding mission. Now, why didn't they do that against Turkey? I think it's, again, going back to its treatment, the assumption that Turkey is a liberal democracy. I think when, you know, military junta does that, it sort of raises the alarm, but not in, you know, in Turkey. And the other examples that you gave also, I mean, beyond reasonable proof, that this evidentiary standard to insist on using such a threshold. And there you see powerful dissents. There were objections within the court also, you know, Judge Bonello, for example, saying, you cannot use this. We are a human rights court. We're not a criminal court. You cannot expect family of an enforced disappeared person to prove disappearance. How can they prove it in the face of government denial, right? So these are, I mean, I can again go on and on. And you said something really important. You said, you know, courts can never really, I forgot how you put the first part. You said, I think, change behavior or change policy, but then you said, but they may contribute to solutions. Exactly. And what the ECHR has been doing, especially in the last 10 years or so, is that it has actually been it has been making it worse by, for example, approving this compensation law as an effective remedy and rejected 1,500 cases by rushing to declare constitutional complaint mechanism to be an effective remedy. Why don't you wait a little? Wait. I mean, don't fine. I mean, give time, of course, give that time, but be there, stay there. Show that you're watching. I think that's the main thing that they could do. They should have done, and empower victims and lawyers. And I think the important thing here is that because it's an authoritarian regime and because there is effectively no judiciary, their supranational courts have to step up in a way to fill this vacuum. There is a vacuum here, right? A justice vacuum in a way. And you're absolutely right. I mean, the ECHR has contributed certainly to development of procedural safeguards and custody, etc. And there, as you know, I discussed in my book the EU factor, and I think there the EU made things a bit. They also made very wrong decisions by prematurely opening the accessions with Turkey, but then effectively ending them right after. So it is very complex, and you are right. I mean, I have no this illusion that the ECHR can do more than that. But we have the Inter-American Court. We know what they can do. I mean, of course, it's a different region, etc. But I think I'll just leave it there. But again, thank you very much, Helen.
Okay, thank you. Thanks for all this explanation and the fantastic question actually Helen just put on the table. Thank you very much again. Before actually leaving the floor to the question from the audience, and I just would like to say a few things. One of the things is Dilek, you mentioned about how Kevin Boyle was struck with the fact that whatever he experienced in Turkey is quite similar to what was happening back then in Northern Ireland. Actually, maybe the similarity was due to Turkish anti-terror law was taken from, in a way, copy and paste from the English counter-terrorism law. Another interesting thing is that you said is about this, compensation law, and when they, introduced these commissions, and then the court started to strike down all the cases. I had 2 cases, similar, two little kids' case actually, and both cases started at the same time, but the procedure lasted for years and years, and one of them finish before the final is earlier, and I took the case before the ECHR, and we find a violation of many articles of the ECHR. Anyway, it's good, but the other client of mine, her case was lasted before the domestic courts longer. And that happened, the case finalized after this law came into account, and then it's compensation law commissions, and the court ECHR struck down, her case, but my other client, who also was the victim in the same case, one of them got compensation, and then the court find violation in her case, but the other one is just the decision was struck down. Actually, I remember when I was young, I was so excited to constantly in my before the Turkish courts, constantly using ECHR case law in my defense, and then trying to persuade the courts to deliver their judgment in favor of my clients. But what happened over the years, after perhaps over more or less 20 years of practice and being an academic, and I lost my faith in ECHR. And in that sense, whatever you are saying is actually resonates among the Kurdish lawyer. I think the court lost its persuasiveness, or the spark he created on us, the hope in our clients will have some sort of justice is now is getting a little bit diminishing. We lost that belief now. Belief in the ECHRs will play its role to deliver the justice in those cases. Anyway, thank you very much. I want to also ask one question, maybe quickly you can answer that, and then later I will open the ground to the audience. And in your book, actually, you mention about 3 phases of ECHR's responses to Kurdish cases. And could you please explain what are these phases, what these phases are, and also what are the possible reasons behind the court's changing attitudes over the years towards the Kurdish cases? Thank you.
Thank you very much, Derya, also for this question, but also for sharing your personal and professional insights and experience. I think that's just so valuable, and you're absolutely, this is something that I've heard, of course, over and over again from your colleagues, our colleagues. The 3 phases, I think, you can, you could perhaps even talk about more phases. These are the ones that I came up with. What I would say, there's no, when you talk about the ECHR's engagement in the Kurdish conflict and its jurisprudence, there's no one story. It changes and there are 2 reasons really, based on 2 factors. One is domestic developments in Turkey, political and legal, but then also developments in the Council of Europe, enlargement, of course. So the first phase is, what I call the golden age. That's that's from the mid 1990s until the early 2000s. There, what we see, despite, my criticisms still hold, but you still see that the ECHR was much more engaged. It was much more active in its oversight. And really, issued these precedent-setting judgments, which set precedent for the entire region, really. And what you see in this period is that you see a tolerant supranational court, tolerant towards victims and tolerant towards lawyers, Kurdish lawyers, who sometimes were making very amateurish mistakes for lack of experience, for lack of course, networks, resources, etc. And the court really, in a couple of ways, for example, relaxed its admissibility criteria, right? The court said in Dchr, the first judgment really in 96, the court said, well, sort of looked at the picture really in the state of emergency region and said, the domestic remedies here are not really effective, so I'm not going to expect that you really exhaust the domestic remedies. I'm going to hear your case. But, and that goes back to also what Helen said earlier, because the court was adamant in not finding administrative practice, although lawyers kept pleading this, the court said, I'm going to still do this on a case-by-case basis. So instead of saying the Turkish judiciary is not working in a state of emergency region, it's not effective, I'm going to, effectively really lift this requirement. It said, I'm going to do this case-by-case basis. But having said that, there are other ways in which the court really relaxed in a way over time. Also, this was incremental in a way. And then the second phase, it's really, there are 2 simultaneous developments happening in Turkey and in the Council of Europe. In Turkey, AKP comes to power, but even before that, before Erdogan comes to power, because Turkey gains candidacy status to EU, reforms start. It's only then, it's only under EU pressure that the Turkish government really starts making, starts making some reforms to execute ECHR judgments. And then, of course, enlargement. Council of Europe, the ECHR is just overburdened, and then AKP comes to power. And I think one of the things that the Erdogan regime saw very clearly from the beginning is that, of course, they wanted to change Turkey's image and that was the right image. Of course, Turkey was, not cooperating with the international community, not allowing UN special representatives to come to Turkey, not cooperating with the ECHR, in a blatant way. And Erdogan changed all of that, Erdogan government, right? They said they really start to cooperate with the government, with the ECHR. But they also understood the importance of creating new domestic remedies to prevent more and more cases to go to the European Court of Human Rights, and also decrease the number of judgments against Turkey so that it is no longer the top violator, etc. And they saw also the docket crisis in Strasbourg, right? And it was in this period that the compensation law that I mentioned was adopted. Commissions were established in Cyprus, because Cyprus cases also was a huge block there too. Another administrative commission was established in Turkey concerning another group of cases concerning lengthy trials. And then ultimately 2012 constitutional complaint mechanism. And what the ECHR did, because it was so preoccupied with its docket, is that what happened to Derya's client has happened as a result, and that ECHR rushed into judgment and said, these are all effective domestic remedies, and sort of in a way abandoned its oversight role to a certain extent. And then the third phase is, and that coincides with the reforms in general in ECHR, a couple of things happened. State violence still continued in Turkey, new kinds of ways of state violence, disproportionate use of force by the police against peaceful demonstrators, tear gas, etc. So you had these Article 2 violation cases, but the court itself, part of the reforms, decided to prioritize among its cases, docket, cases concerning Articles 2 and 3, rather than deciding to take them in the order that they were filed. The court said, I'm going to first prioritize Articles 2 and 3. As a result of both of these, strong judgments came again from the European Court of Human Rights during that phase. Of course, then the fourth phase we could say is the post-coup phase, which I discussed in the conclusion. So there are, there's no one story. I think it's important to be cognizant of that.
Thank you. We have a couple of questions, and I will just read them to you. And one of them is from Dr. Prakasha. Instead of describing a state, and it seems rather also a comment, instead of describing a state, such as Turkey as authoritarian, why not merely say it is not Western? Non-Western states invariably come out as authoritarian and only ambiguously liberal democratic because they are non-Western. Doesn't your case study reveal that human rights cannot function intelligibly in non-Western contexts because of their culture embeddedness within Western culture? This is one of the questions, and if I read like a couple of them, maybe it might be better. Maybe Helen, you may want to answer this, I don't know, as the same question. Where does the international, this is by Elsina Jeffers, where does the international courts fit in with some of these issues? But I'm not sure which issues she is referring particularly, but probably whatever, you talk about, the effectiveness of the court. And third question is, do you see additional dangers for the effectiveness following the entering into force of protocol number 15, introducing the principle of subsidiarity in the text of the convention? Maybe you can answer this, then we can go on to others. Thanks.
Helen, perhaps would you want to go ahead first, if you want?
Okay, I can try to do so. I don't want to take away the limelight from you, especially when it comes to such challenging questions. But I'll have a go at offering a couple of thoughts. So the first one, I'm not going to delve in too much to definitions of authoritarian states and how to categorize. I think a lot of these labels can be quite unhelpful in a way in the context of which we're discussing. But clearly you need a deeply contextual analysis, and that will vary from state to state. I don't accept the idea, though, that human rights, I think the suggestion, the question that it necessarily only operates in a Western context effectively because it's an inherently Western concept. That, of course, is a big discussion. I don't accept that that's the case. Certainly, as someone who's litigated in Africa, for example, I think human rights in many ways has a very strong foothold in Africa. There's been an enormous contribution since the beginning of human rights by the African continent to the concept of human rights and to the practice of human rights, of course, particularly when we're talking about things like group rights, economic and social rights, many issues that are relevant to what we're talking about also in the Kurdish context. Of course, I recognise it's a complex, big question. I don't mean to be too dismissive, but I have to reject that notion. I think that on this, shall I run through quick? I think the second question perhaps goes to the role. There's a reference there to the International Court, and I wonder if that's a reference to the International Court of Justice as opposed to the European Court of Human Rights. Obviously, the European Court applying in the Council of Europe, and then I think it is a good opportunity to make a point here that's quite an important one, which is that the European Court is only one of the international human rights courts or international courts more broadly that have a potential role in Southeast Turkey. So you're talking in your book about the limits of supranational justice, but you are focusing on specifically the European Court of Human Rights. And I think one interesting development that we're looking at also on the Turkey Litigation Support Project is whether we shouldn't collectively be making more use of UN mechanisms, for example, the human rights bodies that tend to be quite neglected, I think, in the Turkish context in general. Also on that, just to say that the International Court of Justice, of course, is the international court where states can bring complaints against other states. So it's an interstate mechanism as opposed to an individual human rights complaint mechanism. But this is also an interesting question on the role of interstate complaints. In the early days, there were some really significant interstate complaints in the Turkish context, but they've been very limited. There should be more interstate complaints because other states should assume their responsibility for dealing with and trying to give effect to human rights processes. So in fact, states are very reluctant to bring cases against other states. Always that's the case, almost always, but there has also been an increase in interstate complaints recently. So maybe in the future, we could see strong interstate complaints again against Turkey. That would be a very interesting positive development. It could mean there would be a role for the International Court of Justice or other mechanisms, also, of course, the European Court in an interstate complaint. And then subsidiarity, subsidiarity, in my opinion, isn't the problem to answer that last question. It's the way that it's being interpreted and applied in this particular context. Subsidiarity is a good thing, right? National systems are supposed to, pushed if necessary by outside factors such as supranational courts, but national courts are the ones who are supposed to carry out these investigations, prosecutions, provide remedies, etc. The problem is just the extent of the deference in this particular context to Turkish justice, absent evidence that the job is really being done. So I hope it won't make a difference. I hope the court will start being more rigorous in its interpretation of subsidiarity in context. So just some observations. Thanks for some excellent questions.
Dilek?
Yeah, I mean, I think, on the first question, I agree with Helen, and also, what does also Western and non-Western mean, right? I mean, how do we then, for example, even if we were to agree with that assertion, and that, which would then explain the Turkish case, then how do we explain Russia and Poland and Hungary, for example, right? So, and again, of course, human rights are universal. I also agree with that. In terms of international, there is a distinction. I mean, the scholarship is moving more and more towards using international courts to refer to all these courts that Helen also mentioned. But I still do find the distinction between supranational courts and international courts to be important. As Helen said, international courts typically, very briefly, they deal with interstate complaints, whereas supranational courts really are based, adjudication is really primarily based on, although not exclusively, on individual complaints. And that's the sort of the audience that I'm addressing to. And, in the interstate, for example, in International Court of Justice, is extremely difficult for also states to plead against each other because, the states must have recognized jurisdiction of the ICJ. Oftentimes they don't do it. They do it on a case-by-case basis, etc. But coming back to the interstate complaint, Helen also mentioned that, I mean, there's now a new trend in the ECHR that we see in the past few years, an exponential growth in the use of this mechanism because it's really been very underused. But what you see is really the ECHR is in a way being drawn into conflicts, ethnic conflicts, or conflicts between states, right? You see Azerbaijan and Armenia bringing interstate complaints against each other, Ukraine and Russia, etc. So in a way, it's really, it is disturbing, because it is, when we think that it is the responsibility, political and legal responsibility of all member states, for example, Holland or Germany, to ensure that the convention is enforced universally. That they have a duty really to bring an interstate complaint against Turkey and others, other countries, but they're not doing that, and that's really very disappointing. And in terms of the subsidiarity, subsidiarity even before Protocol 15, it was there, and certainly we have now new president of the ECHR who's very fond of this principle, and Judge Spano, he keeps emphasizing that. And as Helen said, in principle, it is a good thing, but of course, as long as domestic judiciaries function and are willing to enforce human rights. I have no problem with the ECHR using the subsidiary principle in cases against France, let's say, or Germany, because I think we have a fairly good understanding that you can trust the German legal system by and large. The problem, of course, is authoritarian regimes. Look what's going on in Poland now. Of course, they copycat each other. The judiciary is being transformed. Now, how do you then make any meaningful sense of subsidiarity with respect to Poland, for example?
Okay, thank you. We have another question by Tolga Shirin. What do you think about the fact that the court hasn't delivered any discrimination decision against the Kurds so far? And after that, there are a few comments, but I am just leaving them for now. Maybe you can answer this question first, Dilek.
Thank you very much, Tolga Bey, for this. First, I have to say that this is characteristic of the ECHR's jurisprudence in general. So it's not, I don't in any way intend to argue that this is only against the Kurdish applicants. The court is very, partly, I guess, it is the impact of the civil law tradition. It is very restrained in getting there. And as Helen said earlier, and as I also see in my book in the Kurdish cases, what the court really does is, where it finds a violation of some other article, let's say Article 2, the court basically says it's not necessary to address Article 14, which of course is, bears the question, tell us why it is not necessary. Of course it is necessary, otherwise why do you have this article, right? And it's just, but it's, partly I think it's the civil law effect that could sort of, they're a bit wary about. I think they may think that it's too complicated to find discrimination. You have to, how are you going to establish that? Do we then need to consider statistical information, etc.? There's been cases, of course, where they find that, the very famous case against the Czech Republic concerning Roma discrimination against Roma students in schools. But by and large, it doesn't. Having said all of that, I think I still find it just incredible that the court, because the thing is, when you look, we're talking about here gross violations, enforced disappearances, extrajudicial executions, torture, and forced displacement. With the exception of torture, the others were almost exclusively happening in the Kurdish region, sometimes also elsewhere in Turkey against the Kurds, right? Especially forced displacement and enforced disappearances. That has started to change recently also, but and when you look at these judgments, and when you look at dissent, at some point there was really protest within the court. In one grand chamber judgment, there was actually seven, I think, judges that really sort of said, this is just not. Judge Bonello really, again, he was phenomenal. He says, it just, it's always the Kurds that are being disappeared, that are being tortured, that are being extrajudicially executed, and this ECHR has nothing to say that. I just find it, again, it's not limited to the courts, but it is a big problem, because the problem is, it also has enabled the Turkish regime, has provided the Turkish regime to have a very good counter argument. Of course, there's no discrimination, otherwise ECHR would have done that. Again, when it comes to authoritarian regimes, it's really very important for supranational courts to do their best, to use all their resources, all their tools, use all the address all the claims by the applicants and expose it in its entirety. Don't show this as a individual case, but sort of show how there's a systematic policy, discriminatory policy against the minority.
But do you think, like, it's also because of courts' failure to look at the Kurdish issue or what's happening in one country in terms of like human rights violation, as from like to have a holistic view of what's happening in that country? Like, okay, look, they're just looking at the cases, sorry, case by case, and as if like they are forgetting about the previous case they dealt, and they are just like looking at the case, what they are seeing in front of them, as if for the first time they are seeing it. I think their failure to look at the whole situation from a holistic point of view, it seems, as one of the reasons. And what do you think? Like maybe you can just say a few things about that. And also, what I'm thinking is that it's not only the judges and also the lawyers, when they were presenting their Article 14 violation cases, I think maybe they also lacked knowledge, or they didn't have enough imagination to come up with some kind of like interesting arguments to convince the court to decide against Turkey on violation of Article 16. But I think that didn't also happen, because in one of my recent articles, I am also thinking that there was a room for arguing violation of Article 14 in the case of usage of Kurdish before the court, but that issue has never been picked up by the lawyers in Turkey when they were litigating on this issue before the court.
Yeah, Derya, thank you for these excellent questions, which raises so many. I mean, I have about 2 minutes, but I think it's also good, gives me the good opportunity to sort of maybe sum up some sort of concluding thoughts in a way. I mean, absolutely. I think it is both. I think and that's a good example of the inability, in a way, of Kurdish lawyers to engage in effective strategic litigation, despite all the structural obstacles that they were facing and state violence, obviously. But you don't see this, I mean, you look at sort of comparable cases, and you see this in one case, they've raised Article 14, in another they haven't. Article 18, I mean, it's just been so little raised. I mean, of course, we can criticize the court, but, the court, if you don't raise it, the ECHR is not going to go out of its way to address that. And that's so true. In that sense, they really haven't done their homework. And I think that, again, has to, partly it's because they were very busy, whatnot, but I think it's also partly they, in a way, did not perhaps take it too seriously. Also, maybe, I think, partly because the ECHR was in this first phase so relatively open, it kind of created this inertia. There was this understanding, well, the ECHR is anyway our ally. Anyway, we're going to win. So absolutely different. But the other side of the coin is the ECHR's reluctance to take context into account, historical context, political context, what's going on in that country, what is happening, right to electoral rights, to give meaning to electoral rights. It's one thing to do it when you do in Turkey. Has a completely different meaning in let's say the UK. That's what I mean, that there's a need for contextual approach. And it's so true, the court has always acted as if it's a tabula rasa, as if like they're starting from scratch. Every case is, the court has an institutional memory, and it's strikingly reluctant in a way to actually refer to its own jurisprudence. And we see this in, for example, Article 18 jurisprudence, that it is, how is it that it's only recently that the ECHR has found an Article 18 violation against Turkey? Again, this is characteristic of the ECHR jurisprudence on Article 18 in general. But yeah, I mean, I think I would just, I see that the time is up, so I have to leave there. But thank you for this excellent question.
Yeah, thank you. I think we came to end of our today's event, and thank you very much for your contributions, and I really appreciate the discussions, and now I think what was going to happen, that the SEFTUS have this tradition of taking group photos, and whoever doesn't want to be included in this group photos, please close your cameras. And I think this will be done in a second. And anyway, I think must be done. Okay, thank you very much for everybody, for the first of all our guests and also the audience for their interesting questions. Anyway, hope to host you again in another CEFTUS event. Take care, all the best, bye-bye.